I have lots of questions, Lisa, about this process.
I've got answers.
Okay, good. That's perfect. So let's start with this report that Darren Wilson testified before the grand jury. I should stress again, this is a single source in the St. Louis Post-Dispatch. I don't have any reason to not believe it, but we haven't independently confirmed it. If it is the case that he testified for 4 hours, as the report indicates, how common is that someone who is possibly going to be indicted testifies for that length of time before a grand jury?
It's exceedingly rare because the defendant does not have a right to testify in front of a grand jury. Most of the time, the prosecutors do not want to call them, and most of the time, the defendants themselves don't want to come in and testify because then they give the state a preview of their testimony and they waive their Fifth Amendment rights. You know, Chris, what strikes me here is that every time this prosecutor has had a choice of two different options, he's chosen the one that leans towards the defense. He didn't recuse himself. He didn't file charges against Darren Wilson himself as he could have. And now he's allowing Darren Wilson to testify in front of the grand jury.
Okay, explain that distinction, because that to me is crucial. When you say he didn't file charges against Darren Wilson himself as he could have, he is presenting this case before the grand jury. So what do you mean by that?
Because he had a choice. He could have filed charges himself and had a preliminary hearing, which is extremely common. That takes normally about 1 day. You put a couple of police officers on to talk about their investigation. You only have to establish probable cause, and now you're good. And now you have to go ahead and prepare for trial. Instead, he chose a grand jury, which is a very long process. It's now extended to January, and it's completely secretive. And if there is no indictment, he can say, well, don't blame me, blame the grand jurors.
Yeah, and there's also this report. The St. Louis County Prosecutor's Office is taking an unusual approach. Instead of telling grand jury members what charges they believe police officer Darren Wilson should face, they are leaving it open-ended for now and involving the grand jury as co-investigators. What does that mean?
Yes, that's another one. So once again, every choice they make leans towards the defense. Listen, prosecutors have to be concerned about bringing justice. They have kind of a dual role, but they're also normally an advocate for prosecution and an advocate for the victim. I don't see anyone in this grand jury room who is an advocate for Mike Brown, because every time they have a choice, they make a choice that helps the defense.
So normally, let's say in a circumstance where we weren't talking about a police officer shooting, killing someone, but police show up at the scene and a citizen shot and killed someone, that person would be booked and arrested and charged right away, right? There wouldn't be some long grand jury process.
That is correct. And very often it would be, again, by way of a preliminary hearing where the prosecutor examines all of the evidence, decides what the charges would be, and then goes forward with a preliminary hearing. And if it's a grand jury, the prosecutor is an advocate. They don't just throw everything out there and say, hey, citizens, you figure out if there's something here. Those citizens are not attorneys. They're not prosecutors. They're not criminal attorneys. So they don't know what the right charges are. There needs to be an advocate in there explaining to them what they're supposed to be doing.
Lisa Bloom, NBC News legal analyst, thank you so much.